on an in-depth consideration of the Supreme Court Practice and Procedure Bill 2023 to provide for the practice and procedure of the Supreme Court of Pakistan. The following aspects require due consideration. Article 191 of the Constitution empowered the Supreme Court to make rules regulating the practice and procedure of the court. Under such enabling provisions of the Constitution, the Supreme Court rules 1980 have been made and enforced, duly validated and adopted by the Constitution itself. These time-tested rules are being followed ever since year 1980. Any tinkering with the same may tantamount to interference with the internal working of the court, its autonomy and independence. Our Constitution is founded on the concept of trichotomy of power, three pillars of the state, whose domain of power, authority and functions are defined and delineated by the Constitution itself. Parliament has also been given the power under Article 67 that states, subject to Constitution, a House may make rules for regulating its procedure and conduct of its business. Article 191 states that subject to Constitution and law, the Supreme Court may make rules regulating the practice and procedure of court. Article 67 and Article 191 are akin to each other and recognize the autonomy and independence of each respectively, barring interference of one into other's domain. Supreme Court of Pakistan is an independent institution as visualized by the founding fathers that in the state of Pakistan, independence of judiciary shall be fully secured. With such an objective in view, Article 191 was incorporated and the Supreme Court was kept out of the law-making authority of the Parliament. The competence of Parliament to make laws stems from the Constitution itself. Article 70 relates to introduction and passing of bills with respect to any manner in federal legislative list enumerated in the 4th schedule of the Constitution. Followed and further affirmed are the provisions of Article 142A that Parliament can make laws with respect to any matter in the federal legislative list. Entry 55 of Part 1 of 4th schedule, while empowering Parliament to make laws in respect of jurisdiction and powers of all courts except Supreme Court, especially excluded the Supreme Court. Thus, the bill prima facie travels beyond the competence of the Parliament and can be assailed as a colorable legislation. The Constitution confers the Supreme Court with appellate jurisdiction under Article 185 to 212, Advisory Article 186, Review Article 188, and Original Jurisdiction Article 184. Article 184(3), the focus of bill relates to original jurisdiction of courts, providing the mode and manner for invoking it and providing appeal. The idea may be laudable, but can such a purpose be achieved without amending the provisions of relevant articles of Constitution? Established law is that the provisions of Constitution cannot be amended by an ordinary law, as the Constitution is a higher law. Father of laws, a Constitution is not an ordinary law, but rather an embodiment of the fundamental principles, higher law and law above other laws. In order to meet the scrutiny above, its validity if assailed in the court of law, I have thought it fit and proper, as per provisions of Article 75 of the Constitution, to return the bill with request for reconsideration. जनाब स्पीकर, इस मुअज़्ज़ज़ ऐवान की इंफॉर्मेशन के लिए, ये जैसे मैंने पहले अर्ज़ किया